Greetings and welcome to Part 3 of Live Law's limited series on the most important judgments delivered by the Supreme Court in 2021. If you haven't watched the first 2 episodes, you'll find their details in the description box. Now let's get into today's episode. A constitution bench comprising of Justices Ashok Bhushan, L. Nageswar-Rao, S. Abdul Nazir, Hemant Gupta and S. Ravindra Bhatt struck down the Maratha Quota in excess of 50% ceiling limit, holding it to be unconstitutional. The court unanimously held that there were no exceptional circumstances justifying the grant of reservation to Marathas in excess of 50% ceiling limit as a socially and economically backward class. The bench pronounced the judgment in a batch of pleas challenging the Maharashtra SEBC Act 2018, which provides 16% reservation for Marathas in jobs and education. After the grant of Maratha Quota, the reservation in Maharashtra became 68%. The court by 3:2 majority held that the 102nd Constitutional Amendment has abrogated the power of states to identify socially and economically backward classes, and that after introduction of Article 338 capital B and 342 capital A of the Constitution, the final say in regard to the inclusion or exclusion is firstly with the President and thereafter with the Parliament. In a significant judgment, the Supreme Court on 6 May 2021 upheld the freedom of media to report the oral observations and discussions made by judges and lawyers during a court proceeding. A bench of Justices D.Y. Chandrachud and M.R. Shah held that freedom of speech and expression under Article 19(1)(a) extends to reporting judicial proceedings as well. The bench was delivering its judgment in a petition filed by the Election Commission of India seeking to restrain media from reporting oral remarks made by judges after the Madras High Court orally said that the ECI should probably be booked for murder for being singularly responsible for COVID's second wave by allowing election rallies. The Supreme Court constituted a 12-member national task force to formulate a methodology for scientific allocation of liquid medical oxygen to all the states and union territories in order to deal with the dearth of oxygen supply amid the second wave of COVID. A bench of Justices D.Y. Chandrachud and M.R. Shah constituted the task force, which would be at liberty to draw upon the human resources of the union government for consultation and information, and may also constitute one or more subgroups on specialized areas or regions for assisting it before finalizing its recommendations. The court constituted the task force after noting deficiencies in the centre's formula for oxygen allocation, which was based on hospital beds in a state. The court had earlier flagged that this formula required a relook as it did not take into account individuals who may not have secured hospital admission but are in need of oxygen support. The Supreme Court bench of Justices L. Nageswar-Rao and S. Ravindra Bhatt held that the approval of a resolution plan does not, by that very fact, discharge a personal guarantor of a corporate debtor. The release or discharge of a principal borrower from the debt owed by it to its creditor by an involuntary process, that is by operation of law or due to liquidation or insolvency proceeding, does not absolve the surety or guarantor of his or her liability, which arises out of an independent contract, the court observed in the judgment in which it upheld the provisions of Insolvency and Bankruptcy Code 2016, which applies to personal guarantors of corporate debtors. Section 304B of the Indian Penal Code, which deals with dowry debt, provides that if a woman was subjected to cruelty or harassment soon before her death by the husband or his relative, that person shall be deemed to have caused her death. The Supreme Court in the case of Satbir Singh v. State of Haryana on 28 May 2021 interpreted the phrase soon before as not meaning immediately before her death. The bench of CJI N.V. Ramana and Justice Anirudh Bose observed that it is pivotal to establish a proximate and live link between the cruelty and consequential death of the victim. The court also observed that Section 304B IPC does not take a pigeonhole approach in categorizing death as homicidal or suicidal or accidental. This observation was made while the court dismissed an appeal against conviction under Section 304B, where the accused had contended that the prosecution had failed to prove that a demand for dowry was made proximate to the death of the deceased victim. The bench in this case also issued guidelines for trial in dowry death cases. The Supreme Court observed that the centre's vaccination policy, which did not provide free vaccination for those in the age group of 18 to 44 years, was prima facie arbitrary and irrational. The court also sought to know how the budgetary allocation of Rs 35,000 crores has been spent to procure vaccines and why they cannot be used to provide free vaccination to the 18 to 44 years age group. Concerns were also raised about the digital divide in accessing CoWIN portal for getting vaccine slots. A bench of Justices A.M. Khanvilkar, B.R. Gavai and Krishna Murari issued guidelines for the Central Board of Secondary Education to process the applications for correction or change in the certificates issued by it. The court also directed CBSE to take immediate steps to amend its bylaws so as to incorporate these guidelines for recording correction or change in the certificates already issued or to be issued by it. The Supreme Court on 3rd June 2021 quashed the FIR lodged against senior journalist Vinod Dua for sedition and other offences by a local BJP leader in Himachal Pradesh over his YouTube show with critical remarks against the Prime Minister and Union Government. A bench of Justices UU Lalit and Vineet Saran had reserved the judgment on October 6, 2020 after hearing arguments for Dua, Himachal Pradesh government and the complainant in the case. A bench of Justices L. Nageswar and Anirudh Bose in a suo motu case initiated by the court to deal with the problems of children affected by COVID observed that no adoption of affected children should be permitted contrary to the provisions of the Juvenile Justice Act 2015 and that invitation to persons for adoption of orphans is contrary to law as no adoption of a child can be permitted without the involvement of the Central Adoption Resource Authority. The court also directed the state governments and union territories to prevent any NGO from collecting funds in the names of the affected children by disclosing their identity and inviting interested persons to adopt them. The Supreme Court has held that persons with physical disabilities have right to reservation and promotions also. A bench of Justices Sanjay Kishan Kaul and R. Subhash Reddy held this while dismissing an appeal filed by the state of Kerala against a judgment of the Kerala High Court. The bench followed a judgment delivered by a 3-judge bench in January 2020 in the case of Siddha Raju versus State of Karnataka, which held that the rule of no reservation in promotions as laid down in Indira Sahani case had no application to persons with disability. The Supreme Court directed that all states must implement the One Nation, One Ration Card scheme, which enables migrant workers to avail ration benefits from any part of the country by July 31st, 2021. The court also passed a slew of other directions for the benefit and welfare of migrant workers, like bringing in place an appropriate scheme for distribution of dry ration to migrant labourers, running community kitchens at prominent places, etc. The National Disaster Management Authority has a statutory obligation to frame guidelines for recommending minimum ex gratia assistance for the victims of COVID pandemic, the Supreme Court held in Repak Kansal versus Union of India. The court held that Section 12 of the Disaster Management Act cast a statutory obligation on the part of the National Disaster Management Authority to recommend minimum relief for the victims of a national disaster. Such minimum relief will also include ex gratia assistance as per Section 12 Clause 3, the court held. The Supreme Court on 8th July refused to quash the summons issued to Facebook India Managing Director Ajit Mohan by the Peace and Harmony Committee of the Delhi Assembly Committee, seeking his appearance in an inquiry to probe the role of fake social media posts in creating communal riots in Northeast Delhi in February 2020. However, the bench, comprising of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy held that the Delhi Assembly's inquiry cannot encroach upon prohibited domains of law and order and criminal prosecution, as they are subjects under the domain of the Union Government. The judgment has detailed discussions on the responsibility of social media platforms, jurisdictional contours of legislative assemblies, and the scope of judicial review over legislative committees. The Supreme Court, by 2:1 majority, set aside the provisions in the Tribunal's Reforms Ordinance 2021, which fixed the term of members of various tribunals as 4 years. The majority, comprising of Justices L. Nageswar-Rao and S. Ravindra Bhatt, held that this term violated the express direction given in the earlier judgments in Roger Matthew and Madras Bar Association cases that the term of tribunal members should be 5 years. Accordingly, the bench set aside those provisions. Justice Hemant Gupta dissented, saying that a law cannot be struck down merely for the reason of being contrary to judgments. The Supreme Court on 16 July 2021 observed that religious sentiments are subservient to the fundamental right to life and health in the suo motu case taken against the decision of the Uttar Pradesh government to allow the Kanwad Yatra pilgrimage amid the COVID-19 pandemic. The bench asked the Uttar Pradesh government to reconsider its decision to allow the physical Kanwad Yatra. In light of this order, the Kanwad Sangh on 17 July called off the Kanwad Yatra in Uttar Pradesh after holding consultations with the government. The Constitution 97th Amendment Act 2011 came into force on 15 February 2012. The amendment was challenged before the Gujarat High Court as being ultra vires the Constitution of India. The High Court struck down the provisions of the 97th Amendment to the extent it introduced Part 9b in the Constitution to deal with cooperative societies. The Union of India filed appeals before the Supreme Court challenging the High Court judgment. A 3-judge bench of Justices Rohington Nariman, K.M. Joseph and B.R. Gavai on 20th July upheld the 2013 judgment of the Gujarat High Court. The bench unanimously held that the 97th Constitution Amendment required ratification by at least one half of the state legislatures as per Article 368(2) of the Constitution, since it dealt with an entry, that is cooperative societies, which was an exclusive state subject. Since such ratification was not done in the case of the 97th Constitution Amendment, it was liable to be struck down. There was a split in the bench on the point whether Part 9b will survive with respect to multi-state cooperative societies. While Justice Nariman and Justice Gavai's majority upheld those provisions of Part 9b, which deal with multi-state cooperative societies by applying the doctrine of severability, Justice Joseph dissented on this count. Justice Joseph held that the doctrine of severability was not applicable and struck down the entire amendment. While refusing to allow the withdrawal of criminal prosecution against 6 LDF members in the Kerala Assembly ruckus case of 2015, the Supreme Court made certain significant observations on the scope of legislative privileges and immunities. The state of Kerala and the accused persons had raised an argument that the criminal prosecution was not sustainable against the members for acts committed in the floor of the Assembly, as they are protected by legislative privileges under Article 194 of the Constitution. Rejecting this argument, a division bench of Justices D.Y. Chandrachud and M.R. Shah observed that legislative privileges cannot be claimed to seek exemption from the application of criminal law. The court also formulated principles on the withdrawal of a prosecution under Section 321 of the Code of Criminal Procedure. The court observed that while deciding a plea to withdraw prosecution, the court must be satisfied that the grant of consent subserves the administration of justice and that the permission has not been sought with an ulterior purpose. The Supreme Court observed that the power of governor under Article 161 of the Constitution to commute sentence or to pardon will override the restrictions imposed under Section 433 A of the Criminal Procedure Code. Even if the prisoner has not undergone 14 years or more of actual imprisonment, the governor has the power to grant pardon, reprieve, respite or remission of punishment, or to suspend, remit or commute the sentence of any person, the bench of Justices Hemant Gupta and A.S. Bopanna observed. The Supreme Court observed that the state cannot be allowed to plead financial burden to deny salary to legally serving doctors. Allowing such an excuse raised by a state would amount to violation of fundamental rights under Articles 14, 21 and 23 of the Constitution. The Supreme Court in Dena Bank vs. C. Shiv Kumar Reddy observed that a judgment and or decree for money in favor of the financial creditor or the issuance of a certificate of recovery in its favor would give rise to the fresh cause of action for the financial creditor to initiate proceedings under Section 7 of the Insolvency and Bankruptcy Code for initiation of the corporate insolvency resolution process. Such judgment or decree may be passed by the Debt Recovery Tribunal or any other tribunal or court, and in such cases IRP can be initiated within 3 years from the date of the judgment and or decree, or within 3 years from the date of issuance of the certificate of recovery if the dues of the corporate debtor to the financial debtor or any part thereof remain unpaid, the court held. This was all for today's episode. Stay tuned for part 4 of this series. If you liked this video, do give us a thumbs up and subscribe to Live Law to continue getting regular legal updates. I am Tanya Pandey for Live Law. Have a wonderful week ahead.